In the last 60 seconds, the online legal news world has exploded with one serious claim. New records just came out. Ivanka Trump's timeline is falling apart, and Donald Trump is reacting in a big and intense way. And if you have watched enough breaking legal breakdowns, you already know the first rule here is to separate what is being claimed on social media from what is actually filed, stamped, listed on a court docket, and officially real. So right at the start, we're not treating any viral screenshot, anonymous post, or clipped video as proof of a court action, a new filing, or a confirmed record. We are treating it as a claim that would need a very specific paper trail to be true. And that paper trail is exactly what matters, because the official record does not care about spin. Quick context. Ivanka Trump has been a repeated figure in public discussion around the Trump circle, not only because of her closeness and past role, but because timeline stories, who knew what, when, who was there, what was said, what was written down, are often where high-stakes civil and criminal cases either become something that can be proven or fade into uncertainty. And timeline collapses is internet short language for saying a contradiction is being claimed, usually based on a new document, a previously unnoticed email or calendar entry, a travel record, a company log, a metadata stamp, a sworn statement from another case, or a journalist's summary that makes two dates seem like they do not match. What everyone missed is how small the group of truly new records can be if this is real. In a normal high-profile legal case, the kinds of documents that can truly change a timeline fall into clear categories. Court filings that actually appear on an official docket, discovery materials that become public through a court exhibit list or a judge's ruling, government records released through a formal process, or verified business records introduced through an official record keeper. If none of that exists and what we have is just a social media thread, then we're in guesswork territory, not proof territory. Put this together. The viral headline "Trump goes nuclear" plus Ivanka's timeline collapses is meant to suggest a fast and serious escalation. Something like a strong legal motion, a demand letter, a threat to sue, a new defense strategy, or a political response timed to cover up a harmful reveal. But you cannot confirm escalation without knowing what legal path we are in, because each path has rules. If it is civil court, escalation usually shows up as motions to force action, protective orders, summary judgment papers, requests for sanctions, or specific subpoenas. If it involves possible criminal charges, escalation shows up as lawyer letters, motions to block evidence, motions to limit arguments, immunity claims, arguments about where the trial should happen, or public statements carefully planned not to create admissions. If it is administrative or regulatory, escalation is often a response to an investigation demand, a formal notice, or a referral. Here's what makes this confusing. Online commentators are grouping different kinds of records into one phrase, and each kind needs a different level of proof. Travel logs can be real but incomplete. Phone logs can be real but misunderstood. Company records can be real but depend on context. And metadata can be real but misleading if you do not understand the system that created it. Meanwhile, timeline collapse can mean anything from two dates not lining up to a sworn statement being compared to a document. And those are not the same thing. Now let us look at the 3-day fast timeline that these stories are built around, because the speed of these viral claims usually follows a clear pattern. Day 1, a post appears claiming new records and pointing to a supposed problem involving Ivanka Trump. Maybe a date, maybe a place, maybe a meeting, maybe a message. Then the post gets shared by accounts that focus on fast legal drama. Day 2, commentary channels and political influencers add their interpretations on top of that claim, often quoting each other instead of an original source. And the story hardens into, it is confirmed, even if nothing new has appeared on a court docket. Day 3, the story tries to turn attention into certainty by claiming a response. This is where Trump goes nuclear appears, suggesting either legal retaliation or a political strike. And this is also where the audience feels pressure. Share now because they are deleting it. Watch now because the media will not cover it. Decide now because this changes everything. The twist in this cycle, and the part that separates serious analysis from hype, is that the new record is sometimes not new at all. It can be an old document shared again, a public exhibit taken out of context, or a real record whose importance is being exaggerated because people want a clear contradiction. On the other hand, the twist can go the opposite way. What looks like a timeline contradiction might actually be explained by something simple like time zones, paperwork backdating, assistant-managed calendars, travel that includes private trips not shown in public records, or company systems that record creation dates differently from effective dates. And that is why the only responsible way to cover this is to explain what must be true for the claim. Ivanka timeline collapses under new records to be real. First, the claimed record must be verified, meaning you can trace it to an original authority or a trustworthy record keeper. Second, the record must actually address the timeline issue, meaning it clearly mentions the event date or communication in question. Third, the earlier public timeline must be based on more than feelings, ideally on sworn statements, court filings, testimony, or documents made at the time. And fourth, the difference must be important, not small, because courts care about what matters, and the public often does not. If we are talking about court-related new records, the usual trail is simple. There would be a docket entry, a motion with attached exhibits, a court order mentioning exhibits, or a hearing schedule. If it is a record found by journalists, usually see a description of how it was found, a source type like a public records request, obtained document, reviewed by, and often confirmation from more than one news outlet. If it is a leak, the only responsible position is to call it unverified until it is confirmed, because leaks can be true, but they can also be edited, mislabeled, or completely fake. Now, let us explain Trump goes nuclear in a realistic way, without pretending we have seen a filing. It could mean a public statement meant to influence jurors, donors, and media coverage. It could mean lawyers showing a stronger strategy, more motions, more fights over evidence, more appeals. It could mean threats of defamation lawsuits against people sharing the story. It could mean asking for protective orders or trying to seal documents if sensitive material is spreading. It could also mean an internal political plan using counter stories to slow down momentum. But if you want to know which one it is, you do not follow the loudest video clip. You follow the legal paper trail. Lawyers create documents. Quick context again. Timelines are the backbone of legal stories, and that is why online audiences react strongly when Ivanka Trump's name appears. People are not only reacting to her, they are reacting to what her timeline might suggest about knowledge, intent, and closeness. And those are legal elements that can raise a story from embarrassing to legally serious. What everyone missed is that even if a mismatch exists, the legal effect depends on the setting. In a civil case, a mismatch might affect trust, damages, or responsibility arguments. In a criminal case, it might relate to intent, obstruction claims, or how reliable a witness is. In an investigation, it might change who gets subpoenas next, who is interviewed next, and how investigators test a story. Here is a general expert role summary based on how these roles usually think, not on any special inside information. A former prosecutor would say the timeline is a map for pressure. Contradictions are not automatically crimes, but they can be pressure points, and investigators use records to confirm or challenge. A defense lawyer would stress that timelines are often rebuilt by outsiders who are missing pieces, and the defense job is to provide reasonable alternative explanations, question authenticity, and argue about what evidence is allowed. A law professor would step back and say the legal system is built to favor verified documents and sworn testimony over online momentum, and that internet certainty often does not survive court rules. A forensic analyst would focus on origin, how a file was created, saved, shared, and whether metadata and digital fingerprints, if available, prove it has not been changed. Because a screenshot is not a full chain of custody. A former marshal would remind you that high-profile cases are handled carefully. Security, compliance, and logistics can create records that look strange to the public, but are normal and protected settings. And the lack of a public record does not always mean something did not happen. It can mean the record is not public. Put all of this together and you get the main analysis. Online claims are being treated like final decisions, but what matters is whether the materials could pass verification, be accepted as evidence, and be understood in the right context. Now, the fairness section, clearly showing both sides. If you doubt the viral story, you are right to ask for original sources because false information spreads fastest when it uses legal words. New records can be a marketing term for an old PDF, and timeline collapses can be a forced conflict created by removing context. On the other hand, if you think there may be something real, you are also right that big stories sometimes begin with small pieces. A briefly shared exhibit, a reporter hinting at a document, a local filing that was missed. So the correct approach is not blind trust or automatic rejection. It is careful verification. Show the docket. Show the verified record, show how it connects to an important legal point. Then we can talk. Here's the stakes ladder. Why people care beyond the individuals. First level, legal precedent. Because if a court rules on a new issue about records, timelines, or evidence, disputes in a high-profile case, that reasoning can influence other cases in the future, shaping how lawyers argue about verification, admissibility, and trust. Second level, political impact. Because Donald Trump is not only a legal figure in the public view, he is a political force. And any story suggesting a family member's timeline is collapsing quickly becomes a tool for opponents and is quickly rejected by supporters, increasing division and affecting messaging, fundraising, and voter turnout. Third level, market uncertainty. Because legal instability around major political figures can affect public feeling, media companies, defense companies, regulated industries, and even major stock indexes can shift based on perceived instability. And when markets move based on perception, the difference between verified filings and viral claims becomes financially important. Now, what are the next legal steps? Usually, if and only if there are truly new records that matter. Step 1 is confirming they exist through a verifiable source, an official docket entry, a court order, a public exhibit, or a trusted news outlet providing the document or explaining how it verified it. Step 2 is challenge and response, meaning the other side questions authenticity, importance, or whether it can be used in court, or gives context that explains the dates. Step 3 is judicial decision-making, where a judge decides whether the material is allowed, how it can be used, whether it is sealed, and what deadlines apply. Step 4 is strategy afterward: depositions, extra disclosures, changed filings in civil cases, or motions and witness planning in criminal-related settings. And step 5 is the slow part that no viral clip shows: hearings, written orders, and appeal positioning if the decision is important. Here is what makes this confusing again. The internet wants one shocking document, but real legal turning points often look boring: an order granting a motion to force action, a schedule change, a narrow evidence ruling. Yet those boring steps can be the real turning point that pushes settlements, changes testimony, or shifts risk calculations. So when you hear Ivanka Trump's timeline collapses, turn it into a checklist. Is there a sworn statement being contradicted, or is this just a claimed mismatch against an unsworn story? Is the new record public, verified, and complete? Does it prove what is being claimed or only suggest it? And does it matter legally or only in public debate? And when you hear Donald Trump goes nuclear, turn that into another checklist. Is there a clear legal action you can identify? Is there lawyer activity? Is there a new motion or real-world step with actual results? Or is it a media strategy meant to control the news while the real legal calendar moves quietly? Put this together and the coverage becomes not opinions but documents. You decide, but you decide using standards. The standard is the record, the standard is the docket. The standard is what can be verified, and the standard is what a judge can act on. Quick recap. The online claim right now is that new records have appeared, creating a serious inconsistency in Ivanka Trump's timeline and causing a strong response described as Donald Trump going nuclear. But we are not treating that as proven fact without the normal paper trail, verified origin, docket visibility, or reliable authentication, because viral legal content often confuses shared with filed and suggestive with proven. Countdown next steps. 3. Watch for an official docket signal or a trusted news outlet publishing the actual record with verification details. 2. Watch for the other side's response that either questions the record's authenticity or provides context that explains the seeming contradiction. 1. Watch for the court's decision point: an order, a hearing notice, or ruling on sealing, admissibility, or scheduling, because that is where the story becomes real and the only way that matters. If you want this covered the right way, stay here, because this channel does not give hot takes. We go through documents page by page and follow what can be proven, because the official record does not care about spin.